Thank you all for coming to this lunch talk co-sponsored by the Stanford Law and Technology Association and the Center for Internet and Society. We are extremely fortunate to have with us Marc Rotenberg, the director of the Electronic Privacy Information Center in DC. He's also a professor at Georgetown Law. He's spoken before the 9/11 Commission, Congress on multiple occasions, and in his, I'm sure, ample free time, he's managed to be the Washington, D.C. chess champion. So today he's here to talk a little bit about something that's been in the news more than a little bit recently, the NSA. And without further ado,
great.
Marc Rotenberg, thank you.
Thank you so much, and thank you for being here for this talk. I wanted to say a few words about EPIC, my organization. Encourage those of you who are looking for a really cool clerkship next summer in DC to come and contact me afterward, and then tell you about the case that we're currently litigating, challenging the NSA's telephone record collection program. Is this good? Okay. So let me say a few words about EPIC. I had the very good fortune when I was here at Stanford in the last century, not only to work with wonderful professors and wonderful legal scholars, but also to get to know a lot of the leaders in the computer science community, like Professor Terry Winograd, who were trying to get people to think about the social and political implications in the use of new technology. And when I left law school, I had the great opportunity to go work for Senator Patrick Leahy, who was at that time chairing a new subcommittee that had been established within the Judiciary Committee on specifically technology and law. And he wanted to look at the intersection of the kinds of legal frameworks that Congress should consider and how technology would impact the law. And this was, in the early days, by the way. This is pre-internet, as most of you guys understand it. This was back in the 1980s. And we were thinking about, computer databases and the collection of personal information. We were thinking about what constitutes a computer crime. It actually wasn't until 1984, an auspicious year to be in Washington, that Congress first came up with an independent definition to cover computer crime. And we were working on open government issues and a whole bunch of related developments. I had the opportunity to help draft a law called the Video Privacy Protection Act, the Bork Bill, to protect video rental records. Does anyone here, have any of you actually ever seen a video cassette? I'm just curious. There's a museum, right, of old technology, and there's a little display, and there's an 8-track tape, and there's a video cassette. Yeah, well, that's what I worked on. And after leaving the Senate Judiciary Committee, I spent some time working for Computer Professionals for Social Responsibility, and then I decided Washington actually needed an advocate for the public interest on these issues. Specifically around privacy and open government and constitutional values. I thought the government could take care of itself pretty well, and I thought the private sector could probably take care of itself pretty well. But it seemed to me that the public, needed some help and needed technical expertise. So we put an organization together. We're about to celebrate our 20th anniversary, called the Electronic Privacy Information Center. And we actually started EPIC over the freedom to use encryption, because 20 years ago, believe it or not, the National Security Agency was growing concerned that people might have access to technologies that would make it difficult for the government to undertake surveillance. And they actually tried to establish a standard escrow key encryption that would make available to the government a copy of every person's private key for every encoded communication. And we helped organize at that time what was the first petition on the internet addressed to President Clinton, respectfully asking him to withdraw the proposal for the Clipper chip. We had 42 experts, technical experts and legal scholars sign the letter. We posted it on the internet, And then people started to write to me, and they said, I don't completely understand why encryption's important, but it sounds like that's something that the government shouldn't regulate. I'd like to support what you're doing. Can you please add me to your letter? And in the span of about 6 weeks, we got 50,000 people to sign the letter to President Clinton. Now, I've got to tell you guys, I mean, you're all more recent, but 20 years ago, 50,000 people was about half of the internet. We had a lot of people involved in this campaign. And because of that effort and related efforts, actually the Clipper proposal was withdrawn. And we thought at the time, how cool. The encryption problem is solved. The NSA will go away. We can move on to other stuff, right? And now it's all kind of come back, and it's all come back over many of the same issues. I'm going to jump into our case in just a moment, but there's one other piece that I need to tell you about EPIC, which is that we actually do a lot of litigation when we're not doing these bad web pages. We've done, somewhere down here, 30 or 40 Freedom of Information Act cases to try to make available records maintained by government agencies. We've just settled a whole bunch, in fact, with the folks at the FBI and the Department of Homeland Security and the National Security Agency. That's a lot of fun. We also do a lot of amicus briefs. If there's a privacy case pending before a federal or state court that we think is significant, we will try to get technical experts and legal scholars together. We'll write a brief for the court on the issue with our own perspective. Chip Pitts, who's a member of our advisory board, has participated in several of these briefs, and we've actually had the good fortune of having our briefs cited in a number of opinions, although I have to admit it's been more often in dissent than in the majority, but you have to start somewhere. So this is just by way of background of saying that, you know, I've spent more than 20 years thinking about the intersection of law and technology. I've been able to see the debates in Washington from the point of view of Congress in terms of how the courts understand these issues, certainly with some concern about how they impact the public. And I have to say, in all that time and all the congressional hearings and all the cases that we worked on, nothing really prepared me for a document I saw earlier this summer, which is this. This is an order signed by a judge on the Foreign Intelligence Surveillance Court in April of this year, pursuant to authorities created under the Foreign Intelligence Surveillance Act. It was submitted by the Department of Justice on behalf of the Federal Bureau of Investigation, compelling a U.S. telephone company, Verizon, to provide all of the records on its customers, the so-called telephony metadata, for communications, between the United States and abroad, or wholly within the United States, including local telephone calls. Okay? That is the so-called Verizon order that was among the first documents that Mr. Snowden released earlier this summer. And I'm not going to get into the debate about Mr. Snowden. I have some views. But as a lawyer and part-time law school professor who spent quite a bit of time studying privacy law in the United States, studying and reviewing the Foreign Intelligence Surveillance Act, I have to tell you, I don't think I have ever had a moment in my life as I did when I encountered that page on this order. what it was that I reacted to was the thought that the Foreign Intelligence Surveillance Court, which had been established by the Foreign Intelligence Surveillance Act to collect foreign intelligence subject to analysis by the National Security Agency, could produce an order providing for all of the telephone records on solely domestic communications. You have to pause for a moment and just understand how almost completely upside down that outcome is from the intent of the law, the structure of the court, how everyone in Washington who is not cleared and familiar of this program generally understood this issue to be handled. And, you know, there was part of me, and I'm not kidding about this, there was part of me that looked at this and said, this is off of some test. One of my colleagues somewhere is, you know, asking a question about what would an unlawful FISA surveillance order look like. And this is probably attached to the test, right? And the students who studied FISA that term will be expected to locate that sentence and go, aha, there it is. A court could never do that under the statute as written. So I had that thought for a moment. But then I also thought about other people who are teaching privacy law, and I realized no one would take the amount of time required to put this together. You know, we would keep things much more simple. And there's a lot of detail here about what constitutes the call record information, the so-called telephony metadata information that Verizon was required to provide to the NSA. So the next thing I did after I read the order, which runs just a few pages, and it's signed here by Judge Vinson. There's also, by the way, for those of you who are familiar with this area of law, also the gag rule, right, which is that no one who receives the order is allowed to disclose it or discuss it to anyone else. That's an issue in a number of the surveillance cases that are currently being litigated. But my next reaction was, okay, let me just talk to someone else. Let me call up a few of my friends. Let me share this with them and ask them, do they have the same reaction I do? Am I just misreading it? I mean, maybe there's, you know, some semicolon in there that I didn't see or was a typo or something. And I said, no, you're probably right. Now, this is where it gets interesting because having taught privacy law for many, many years, one of the things I always say in my first class to students is, you know, the world is filled with concerns about privacy. And we could spend the rest of the semester talking about how worried we are about what we post on Facebook or whether people hear what we say on our cell phones. I mean, you can go on endlessly and think about all the privacy risks that we experience every day. But the cool thing about privacy law and being a lawyer in this field is that it gives you the opportunity to ask yourself the question, when you become aware of a privacy problem, what is the legal strategy to get the outcome you seek? If you're not happy, for example, when Google decided that it needed a social network service to compete with Facebook and wanted to turn its Gmail users into Buzz users, you can go, hey, that's just really unfair and they shouldn't do that because I didn't sign up for that. Or you can do what we decided to do, which was to file a complaint with the Federal Trade Commission and say it's actually an unfair and deceptive trade practice to sign people up for a service that they didn't consent to and release their personal information to help launch your service. And the FTC actually agreed with us. And there was an investigation. Google backed off Buzz, and there was a big privacy program put in place. But this is actually an illustration of the larger point, which I'm making now, is that having uncovered this problematic order, the question you need to ask yourself next as a lawyer, as an advocate, is what is the solution? And the solution, I guess, suggested by the way I've asked the question is you want the order overturned. You want a court to say, under the relevant law, this judge did not have the authority to tell the Verizon Corporation that it must turn over all of the customer record information that it possessed. Now, let's see if we can go to that relevant law. So you've seen now the magical words here. And what we're going to do next, we did a conference at the National Press Club last month and had a bunch of speakers. And we put together a pretty good web page. If you're interested in learning more about the case, a lot of that is here. And what I'm trying to find right now is the, let's see. Well, maybe there's a simpler way to do this. Let's go Patriot Act, Section 215. Okay, I'm going to use Wikipedia, but we're just going to keep that among ourselves, okay? Because if this gets back to Georgetown, I'm in a lot of trouble. Gosh, I just need some text. It's all over our brief, but I thought it'd be easier to look at. That's not so helpful. Let's find some other place. Oh, that's not so helpful either. All right, I may just jump right into the brief. So you're going to see in a moment, I'll walk you through it. This is the petition we ended up filing with the Supreme Court. The petition turns on our reading of the relevant law, which is Section 215 of the Patriot Act. I think that's codified at 50 U.S.C. 1861. And I want to see if I can get that for you. Statutes involved. So we're going to go down to okay. There's the order we just discussed. There's a declaration. There are provisions. And here's actually the so-called business records or tangible things provision in the Foreign Intelligence Surveillance Act. This is language, by the way, that originated in 1998. The act itself was passed by Congress in 1978 to regulate the collection of foreign intelligence in the United States. The 1998 amendment created the opportunity to gather business records, and then this was modified post 9/11. But the critical language in Section 215 of the Patriot Act that's at issue here let's see. All right, there it is. Sorry, I've normally pulled the text out directly from the Act, so this is a little bit new to me, but that's what we're going to talk about here. To get this order, what the government needs to provide to the Foreign Intelligence Surveillance Court is basically set out here. A statement of facts showing that there are reasonable grounds to believe that the tangible things sought are relevant to an authorized investigation conducted in accordance with subsection A2 to obtain foreign intelligence information not concerning a United States person. And it goes on, and there's some other qualifying language in there. But if you are familiar with the broad strokes of our claims and the dispute, you know that this is largely a case over the question as to whether all the telephone records that the government compelled disclosure of can reasonably be viewed as relevant to an authorized investigation, right? Our view is that it is very difficult through any plain textual, common sense, legislative history perspective to reach the conclusion that this language created such broad authority that the government could require not only Verizon, but in fact every other telephone company in the United States to provide records on its customers. Now, we have some very good support for our interpretation of that language, because the congressman who wrote that language, the author of the Patriot Act, James Sensenbrenner, said this language was never intended to be used in that way. Okay? He said that after the disclosure of the order, and there is legislative history to support that view as well. And so the question then becomes, how do we make the argument to the court that they must overturn, vacate the order below? I'm not going to go through the whole brief. In fact, I want to leave you all some time to ask questions. But I will show you, briefly from the table of contents, the basic structure of our argument. And the part, the big part of this case, the difficult part of the case, is the fact that we went to the Supreme Court in the first instance to ask to have the Fisk order overturned. You will learn, if you haven't learned already, that the Supreme Court is typically the very last place you go to when you're pursuing any litigation in the United States. And that's true for lots and lots of good reasons. But there are things about this case that we believe, and we argue in our brief, that create the types of circumstances that justify review by the Supreme Court in the first instance. And we explain, for example, why it is that we simply can't go to another court to obtain the relief we're seeking. We can't go to a district court and say, look over at what another group of Article III judges did over here. We want you to vacate that order. They don't have the authority to do that. And we can't go to a court of appeals because this is not a decision from a district court. And the Foreign Intelligence Surveillance Court of Review, which looks kind of like a court of appeals, provides no basis for standing for us. And the government itself has said that that's not an avenue to seek redress. So a big part of our argument at the outset is why we ended up at the Supreme Court. We had no choice. It was the only court, in our view, that could hear our claims. We explained, as I have already, how, in our view, the Judge Vincent order exceeded the court's authority. And then we walked through the circumstances that would justify mandamus review. Now, part of what I told you at the outset about the type of organization EPIC is are actually relevant facts to explain why it is that we're in court challenging the order. We're not just a group concerned about privacy. We're a group actively litigating cases against government agencies, and we are, by the way, a Verizon customer, right? So those same agencies, and did I mention the NSA and the FBI earlier? Because I meant to. Those same agencies have just obtained from our telephone company all of the records of our communications. Am I arguing that they did that purposefully directed toward us because they were really concerned about what our next brief might contain? No, I'm not. I'm simply trying to establish that we have standing to bring this claim and that there is a significant interest implicated when confidential attorney-client communications are obtained by the government in what we contend is an unlawful fashion. We note some of the other activity that we engage in. We believe that's First Amendment protected activity in pursuit of our advocacy efforts. And we also, it's always good if you can point this out to judges, by the way, that their telephone records, as well as the telephone records of members of Congress, might be at issue as well in the government's program. I think it's a good argument. I mean, I have to feel that way because, of course, I wrote it. A lot of people, first heard that we were bringing this case to the Supreme Court said, that's a little ridiculous, right? I mean, this program's been going on for several years. They have broad authorities. It's post 9/11. You don't bring a case first to the Supreme Court. What do you expect is going to happen? The government is probably going to ignore and not even file a brief in opposition. That's what people said at the beginning. And then something kind of remarkable happened, which is a bunch of other legal scholars started to read the brief, look at the order. Former members of the Church Committee, the members of Congress who helped write the Foreign Intelligence Surveillance Act of 1978, read our brief, including former Vice President Walter Mondale, and said, we'd like to support this. What do we do? And suddenly it felt to me like that moment I had 20 years ago when we had sent a letter to the president about Clipper, signed by 42 experts, and people started sending emails and said, how can we help? We had legal scholars all across the country offering to write amicus briefs. And I'm going to show you in a moment what some of those briefs look like. One of the big issues that people had identified in our case, which they said would be the critical flaw. There was just no way we could overcome the fact that the court lacks jurisdiction to hear a question of this type in the first instance. So we got two of the leading authorities on the jurisdiction of the Supreme Court, Professor Vladeck at American University and Professor Fander at Northwestern, to write a very nice amicus brief solely on the question as to whether or not the court could take the case. They weren't even going to address the merits as to whether or not the activity under 215 was lawful. They just wanted to provide the analysis for the court that would establish that there was no reason that the petition we filed couldn't properly be heard. We had another brief from the Cato Institute. Now, one thing that might have occurred to you at this point is I've outlined for you actually a fairly modest, narrow argument. I haven't said a word about the Fourth Amendment, for example. In fact, we purposefully excluded all the constitutional claims in our petition. We wanted to give the court a very narrow question to answer, which is, did the judge exceed his authority under Section 215 when he issued that order? Well, the Cato Institute, God bless them, if I can say that, they wanted to go much further. And when Randy Barnett, who's the law professor colleague who actually argued against the Affordable Care Act with great force before the court last term, said, I'd like to do a brief in support, because I think in addition to the 215 claims you've raised, there are very significant constitutional claims, and we'll go ahead and set those out. I said that would be great. So that's our constitutional argument against the petition. We've got a bunch of legal scholars led by Professor Fred Cate, at Indiana University, and by the way, a classmate here from Stanford. We were both in class of '87, so go Stanford. He wrote that brief. And finally, as I had described for you earlier, this was the brief of legal scholars and former members of the Church Committee, signed by Senator Gary Hart, signed by Vice President Walter Mondale, basically saying that the Foreign Intelligence Surveillance Act could never have been used to collect solely domestic communications, at least not the law that we had written. So let me tell you where we are. We filed our brief. We got 4 outstanding amicus briefs. I got a call from the Solicitor General's office. Everybody said they were going to ignore it. They didn't think it was a big deal. The first call said, we think we need a 30-day extension. This case is more complicated than we thought. I have to say, being on the other side of that conversation many, many times in my career, it was really a lot of fun to get that call. I pressed the hold button for just a moment, kind of savor the moment. Just wait it out there. Pressed it again. Okay, we'll give you the 30 days. And then actually, a bit of time passed, and they called again, and they said they wanted another 30-day extension. Okay, another 30 days. Now you know how some of your professors feel. We learned 2 weeks ago that the briefs were distributed to the justices on October 30th, that the issue has been scheduled for the November 15th conference, and sometime shortly after November 15th, we may hear something, right? They may make a decision at the conference. They may put it over. What could happen? This is a very unusual case, to be sure. The court could simply deny our petition. Lots of important issues raised, to be sure, but the court could conclude they should not be resolved in the first instance at the highest court. It's a possible outcome. The court could be simply persuaded by our briefing that the order below exceeded Section 215, conclude that the issue had been adequately briefed, and vacate the order. That's what we hope happens. That's why we filed the petition. The government has had the chance to file its opposing brief. The court will have heard those arguments. Or the court could reach the opposite conclusion. The court can say the issue's been briefed. We agree with the government. The order is upheld, in effect. Or there could be something that looks a bit like a grant of cert, in which case the court might schedule arguments and perhaps ask for further briefing. I don't know what the outcome will be. I'm kind of hoping for that vacate the order option, because that's what we filed. But in any case, you know, it's an interesting case that we're involved in. I just wanted to tell you a bit about it, give you some sense of how it evolved. It was quite unusual. It really was just looking at that order that had been released earlier this summer and having the thought, courts don't have the authority to do that, at least not under the current law. And that's why we brought the petition. So I'm going to stop here and answer any questions you might have. And thank you again for taking some time.
Please raise your hand and we'll deliver a mic to you. Thanks.
A couple of questions. One is, how'd you find out about the order? Number 2 is, why didn't or did Verizon oppose it or, you know, try to overturn it, rehearing, appeal, whatever? And the third is, why wouldn't you want the court to sort of tell you what, you know, why it's out of bounds? So you might get an opinion that enables you to understand, you know, what's in or outside the law in that case.
Right. Okay, so those are 3 excellent questions. How did we learn about the order? Frankly, it was the publication by Mr. Snowden. A lot of documents have been released this summer. Many of them describe the technical capabilities of the National Security Agency in its collection of data and its interception of communications. But this order was unusual because it was a legal document, and I understood when I looked at it what its implications were. Since the publication of that order, as you may be aware, there have been efforts to reform some of the practices of the Foreign Intelligence Surveillance Courts. Several other orders have now been published. Several opinions have been made available. And I think that's all very good. But our reaction was based on the release by Mr. Snowden of the document. Last question you asked is, would we get, I'm going to try to remember the one in the middle. I'm sorry. Oh, so that's a good question, too, because the question has been raised since under the way the statute describes, a form of objection, only the telephone companies themselves upon whom the order is served, according to the statute, can object. And so the interesting question is, do they, in fact, object in any circumstance? And a letter that the Chief Judge for the Foreign Intelligence Surveillance Court, Reggie Walton, sent this summer to my former boss, Senator Patrick Leahy, said flatly there had never been an objection by a telephone company to one of these Section 215 orders, which is something we noted, by the way, in our reply brief, because the government, in opposing our claims, said there are opportunities for others, such as the telephone companies, to object if they think the orders are excessive. But by that point in time, the letter from Judge Walton had been made public, and so we knew as a matter of fact that such an objection had never occurred. And we thought it was important for the court to know that, right? And the third question is, would it help if the court somehow clarifies the use of the authority in this instance? And I think what the court needs to do is to answer the question whether or not the use of this authority was lawful. I think it really is a binary outcome, right? Now, what happens next is that Congress could make a determination following a judgment by the court. If the Congress were to decide such expansive surveillance authority in the United States was appropriate, then by public law, you would change the language in 215 to make that possible. But our view is that the current law doesn't allow that. And if the court reviews the language of the Act, we think they'll reach the same conclusion. And then Congress will have to make a determination.
From legal grounds why it's important to have a very narrow focus here. I'm just curious, given this breadth of things that have been coming out about NSA, what the status is of legal challenges to the wider program of what they've been doing.
Well, there are a wide range of challenges that have been brought. The ACLU has one. The Electronic Frontier Foundation has one. Other organizations and individuals have brought challenges. Some of them are quite broad. The ACLU case in the Southern District of New York, for example, they are suing 5 different agencies trying to seek various forms of injunctive relief. We purposefully chose, and it's partly, I think, out of respect for the court, a very narrow issue. But it was actually a very narrow issue on which I think we could win, right? We could have, talked a lot about, George Orwell's 1984 and, the panopticon and, Fourth Amendment liberties and general warrants and all that sort of stuff. But in going to the court, we actually wanted to present a narrow question that we thought, even thinking about the members of the court today, most would say, that may be right. So that's where our case fits into the mix of the others that have been brought.
Hi, I read recently in the newspaper that the Department of Justice notified a criminal defendant that some of the evidence that's going to be used against him came from this program, possibly leading to a motion to suppress and a district court ruling on the merits of the program. I'm curious how you think that might affect your case and challenges to the program in general.
So it's very interesting, and that's a recent story. One of the problems with the Foreign Intelligence Surveillance Act is it creates such a secretive procedure that by the time you actually get some evidence that might be useful, understandably, the defendant will want to challenge how that evidence was obtained, which is how you get to the suppression hearing. And in this instance, it may be one of the other avenues to get judicial review of this authority. But even that case, as well as the ACLU's case, doesn't get to the central question that our case does, which is whether the court had the authority in the first instance to issue the order. And in that sense, we think our claim is unique and can only be heard by the Supreme Court. So I'll be interested to see what happens in these other cases, but those cases won't resolve the issue that we've raised. Yes, in the back?
I read something about this 215, that there's a line in there that said relevant to the investigation, and that there had been some sort of maybe it was an administrative ruling inside the administration that said it's relevant to the investigation because, and then there was a relevance established. That's one question. And then secondly, what, if any, weight does the words of the author of the bill have in a court? I can understand what logically it might have to me, but I don't know whether a court considers a member an indication of legislative intent.
Well, it's a good question, and of course there are a lot of different theories about the value of legislative history. I am quite certain of this. It doesn't hurt us, being the petitioner in this instance, that the member of Congress, who most people agree is responsible for that text, has said quite emphatically that's not the interpretation that we intended. We, in our brief, go into quite a bit more of the history associated with the changes in 2006, and we note statements, for example, from then Senator Arlen Specter about the need to ensure specificity in the use of the authority, which is helpful as well. And there's a little bit of language in the committee report. But then there's also, and you see this in the Cato brief, I think a very clever linguistic argument, which is to say that you obtain information that's relevant to an authorized investigation, assumes in the first instance that there is in fact an investigation and that there's a way to determine a nexus between what you've obtained and the investigation that's underway. And the significance of that is because when you dig a little bit more deeply into the white paper, for example, which has been set out as a justification for the 215 program, you get the sense that a lot of this is being done prospectively, which is to say, in anticipation of a future investigation, we need to have now this information available to us. And it's very difficult to find in the plain language of 215 the authority to obtain this type of information for that purpose. There's a phrase here, a sentence from the government's brief, which I think is very interesting. The government says, in part, all of the records are relevant to an authorized investigation because it is only with the full set that this investigative tool can be used most effectively. And that view is also reflected in one of the opinions from a Fisk judge, Judge Egan, who wrote about the necessity to have all of the data available to the government to be able to fully conduct the search they intend to pursue. Now, my view, and this may surprise you, my view is that that may be correct, and maybe the government needs to be able to do that. But I don't think they have the authority in current law to do that. And if that's the authority that the government is seeking, I think they need to go back to Congress and make that argument, get the language amended, and then be able to engage in that type of prospective collection activity that they believe is necessary. I just don't think they've gone through the necessary step at this point, which is to be able to operate under a legal authority that allows that activity today. So,
the government has made a big deal about the difference between the content and the metadata, whereas the metadata has a huge amount of information revealed in it. Can you explain your position or expand on your position on whether that's an actual distinction and
well,
where it is in law?
In the background of this case is a fascinating issue that many people in the privacy world are following closely, which is the court's possible reconsideration of a 1979 case, Smith versus Maryland. And Smith versus Maryland is the post-Katz case, which basically said that you don't have an expectation of privacy in the telephone numbers that you dial. And it's largely in reliance on Smith versus Maryland that the government has contended now in many different settings that there is no constitutional claim with respect to simply telephone record collection as opposed to the underlying content. Now that is today a very fragile argument. It's a very fragile argument because when Smith versus Maryland was decided, the network was analog and telephones had rotary dials, you know. And there was even a lot of predicate evidence in that case that established why they were trying to get one particular person's telephone numbers dialed. Today, we are about as far away from that conception of telephone record information as one could imagine. Because, of course, in the digital world, where the data is easily linked and reveals all sorts of activities, not only about yourself, but about people who you communicate with, the profile provided by the data may actually be much more revealing than the underlying content. And a lot has been written about that issue. It's suggested also in the concurrence by Justice Sotomayor in Jones, U.S. versus Jones, the GPS case from the 2011 term. And it's a fascinating issue. Now, I don't know if the court's going to get to it here, but they will soon, I suspect. And it is that point. Yes?
You spoke a little bit about the unique nature of going to the Supreme Court for review and especially seeking review of a FISC decision. I was wondering, did you mention in your brief or have any of the amicus address the issue that the Chief Justice appoints the members of the FISC court? And do you have concerns about Chief Justice Roberts reviewing decision of people he appointed?
Yeah, I mean, it's an interesting issue, and it's been written about in terms of the composition of the court. But I can fairly say, I think one of the wonderful things about working on the privacy issue is I can look at the court today and imagine that any member of the court, including the Chief Justice, could agree with us on the merits of this petition. I had the experience actually during the nomination of then Judge Alito to the court, who you probably know was opposed by many progressive organizations. But I got word that he had done his undergraduate thesis at Princeton on the right to privacy in America. And I contacted the Princeton librarian during the nomination hearing, and I said, could you please, send me a copy of the thesis? And they sent me the copy, and I found some great language in there. And so Justice Alito, now on the court, we write briefs and we cite, what the justices have said in previous opinions. I'll write amicus briefs and I'll cite to Justice Alito's college thesis, because he said some great stuff on the right to privacy. And what got me thinking about this in particular, because the question you asked about the fact that the chief today appoints all of the members of the Foreign Intelligence Surveillance Court, get a load of this. In 1971, 7 years before the FISA was passed that created the Foreign Intelligence Surveillance Court, Samuel Alito, a senior at Princeton, described the need for a new court of review for national security warrants and said that the selection process for that court should be done by the members of Congress and the president. Okay? I mean, not only did he anticipate the need for a court to regulate this activity, he even described what the composition might look like. So my view with respect to many of these issues is they're really open questions. I'm not concerned about Chief Justice's selection of the FISC judges. One or two more questions? Yes.
The fact that in your case, Verizon didn't resist the order from the FISA court. And I'm curious if you could flesh out, if they had, or if any other private company had, what would that look like? And then more broadly, when the government is coming to private sector companies for any kind of data, metadata or content or whatever, what kind of ability do those companies have to resist? And what's the implication? Like, could you flesh out this sort of third-party doctrine as it relates to any other kind of data, not just metadata, if we've handed over data to private companies?
So one of the other issues that's raised in our case is the fact that the order was served on a company in possession of our records. And under the so-called third-party doctrine, the court doesn't typically recognize the claims of the individual to whom the information pertains when held by a third party. Now, there are lots of ways to address that problem by means of statute, and I've spent a lot of time over the last 20, 25 years writing privacy statutes that place obligations on private companies when it comes to government requests for data in their possession. But as a matter of doctrine, and because of a case from the 70s called U.S. v. Miller, the court has essentially said that we don't have a Fourth Amendment claim with respect to the data disclosed by Verizon. This doctrine, I think, is also going to get closer scrutiny in the years ahead, like Smith versus Maryland, and in part because of the Sotomayor concurrence in Jones. So, we'll just, I guess we'll have to see what the outcome will be. But that is part of the case as well. So, yes, sure.
Just in terms of like your procedural, just in terms of your procedural posture and going to the Supreme Court first, I understand your arguments and I find them pretty persuasive myself, but just to like further insulate you from any claims from the government, why wouldn't you necessarily try to go to a district court first, get dinged, then go to a circuit court, get dinged again, and then go to the Supreme Court ironclad in that respect?
Well, typically, of course, that's what we would do. But what's interesting, when I listen carefully to the people who made that argument, why we should go to the district court first, and the government says this, by the way, in their brief. They say EPIC should do what the ACLU did and seek injunctive relief in the district court with regard to the actions of government officials. But that's not the relief we're seeking. I'm not suing the Attorney General or the Director of the FBI for the actions they took pursuant to the court order. I am seeking to have the court order itself vacated because I believe the judge exceeded his authority when he issued the order, right? Which is not injunctive relief. So all those theories about going to a district court to obtain that type of relief do not give me the opportunity to challenge the lawfulness of the order, which I think I'm entitled to, because that order impacted rights in terms of our telephone records now in possession of the government. I have to say in fairness, I'm not quite at moot court level yet, and I'm not sure that there'll even be an oral argument in this case. But that is, I suspect, going to be one of the key questions that would be raised if we get to an argument. Why didn't you go to district court? And as I said, my answer at this point is that that would not give me the opportunity to have the order vacated. And that's essentially the theory of our case. I wanted to say one more point on the question you asked, which is about the transparency of all this activity, because one of the other consequences of these decisions being made by the Foreign Intelligence Surveillance Court is that we learn very little about whether or not companies oppose, what records are disclosed, what the justifications are. I had the opportunity in the spring of 2012 to testify before the House Judiciary Committee when the FISA Amendments Renewal Act was up before Congress. And they said to me, essentially, do you think the act should be renewed? And if it's renewed, should we do anything different? And I explained to the members of the committee that I certainly understood why we had this parallel system Foreign Intelligence Surveillance Act, apart from our regular procedures in criminal law for electronic surveillance. But I said, you know, there's too little reporting of these activities. And someday the public is going to learn about things going on, and they're not going to be happy. And I said at that time, before renewing the act, I think you should have new publication requirements. You should make the opinions of the court routinely available when they can be made available. You should provide some data about the use of these legal authorities so that we can evaluate how effective they are. You don't need to do things that jeopardize ongoing investigations. But if you have more transparency, you will have more public confidence in the use of these legal authorities, which seemed to me at the time a pretty good argument. Now, of course, Congress renewed the law without any changes, without any new reporting requirements. And then, of course, we all learned that there have been opinions issued by the Foreign Intelligence Surveillance Court which established that the NSA has exceeded its statutory authority. The President has taken steps, somewhat along the lines that I had proposed in 2012, to make opinions of the court publicly available, to make data about the use of the authorities publicly available. And these are all steps in the right direction. So I support that. But as to this case, this claim, this order, even with some of those good changes that have taken place, this activity is still illegal. And if you're, you know, a lawyer and you're trying to figure out how to take a privacy problem and come up with a solution, you know, this is the solution we've come up with, and we just have to get the court to agree with us. So I think I'm going to stop there and thank you all again.